Good morning again. I am Lauryn Guttenplan. I'm the Associate General Counsel in the Office of General Counsel for the Smithsonian. I just celebrated my 29th anniversary with the Smithsonian, so I like to say sometimes that I was there at the creation, and I mean of NMAI. The last panel was really very special for me. It was a walk down memory lane because I attended that 1987 hearing that Pat talked about, where Secretary Adams was asked by Senator Inouye about our 18,000 remains in the Smithsonian's collections, and was also able to participate in many of the discussions and negotiations that led to the creation of the museum. But more about that in a minute. Let me also say that the issues of repatriation, of which I've dealt with many of them over my almost 30 years, have provided me with some of the most interesting and rewarding work of my career. And I think for those of you who are here and are able to hear about this process that has gone on for 25 plus years, I'm sure you share that view that these issues are so important and so interesting as well. So with that, I am honored, of course, to be here to moderate this panel. And today we are joined by 4 distinguished panelists: Kevin Gover, the director of the National Museum of the American Indian; Brenda Toinita Pipestem, a citizen of the Eastern Band of Cherokee Indians and chair of the Repatriation Committee of NMAI's Board of Trustees; Jonathan Coddington, a senior scientist at the National Museum of Natural History; and Bonnie Newsome, a citizen of the Penobscot Nation and chair of the Smithsonian's Repatriation Review Committee. I'm not going to go into detail about all of their very distinguished careers. Their bios are in your packets, and please review those at your convenience. So we can take our time to talk about these important issues and to survey the road that we have taken over the past 25 years with regard to repatriation, the challenges and opportunities that remain as well, and what might be in store for the future. We'll follow the same format as the last panel with presentations, and then I will ask a few questions of each panelist, and then if there's time at the end, we'll take questions from the audience, and you have index cards in your packets if you'd like to write your question out, and then there will be microphones in the back. So I arrived at the Smithsonian as a young lawyer in 1985, just about the time that the Museum of the American Indian High Foundation in New York was looking for a home after the unsuccessful offer from Ross Perot to move to Dallas, Texas, as you just heard Suzanne describe. When that failed, the High Foundation initiated discussions with then Secretary Robert Adams to transfer the collections to the Smithsonian. And as you heard also during that previous panel, that effort with Senator Inouye's legislative efforts resulted in the NMAI Act of 1989. So the NMAI Act did 2 things, essentially. It established the museum, its mission, facilities, governing structure, but it also provided for the repatriation of human skeletal remains and funerary objects in the Smithsonian's collections, which at that time had been exclusively housed in the Museum of Natural History. Prior to that time, the Natural History Museum had voluntarily repatriated remains of named Native American individuals to descendants, but it was really only with the passage of the NMAI Act that repatriation of certain Native American materials became a legal as well as a moral imperative. And it has really been my privilege to bear witness to this history, so eloquently laid out by the previous panel, and I really look forward to the reflections of our panel shortly. So any review of repatriation at the Smithsonian really has to begin by answering 2 questions, and these have been touched upon previously. So let's start with the easy one, which is why the Smithsonian is not subject to NAGPRA, and Pat talked about that previously. The NMAI Act was the first piece of repatriation legislation, and it applied only to the Smithsonian's collections. So when Congress decided to extend the repatriation requirements to other federally funded institutions, it made sense to carve the Smithsonian out of NAGPRA because we were already covered by the NMAI Act. But the problem was that NAGPRA was broader in scope. It not only included repatriation of sacred objects and objects of cultural patrimony, but there were other distinctions as well. So in 1996, Congress amended the NMAI Act to bring it into closer conformity with NAGPRA. And you have the acts and the amendment in your materials. So while the laws are not identical, they overlap in many respects. And one of the most significant differences is that the Smithsonian does not fall under the purview of the Repatriation Review Committee under NAGPRA. We have our own external review committee, and today you will hear from Bonnie Newsome, the current chair of that committee. But for purposes of our discussion, we're going to focus on the NMAI Act. The next and more difficult question, I think, is why our two museums, the Museum of the American Indian and the Museum of Natural History, have parallel but different procedures for handling repatriation. Now, to answer that, we have to look at the nature of the Smithsonian and the NMAI Act. Although the Smithsonian is a single legal entity that operates under the governing umbrella of the Board of Regents, each of its 19 discrete museums and research institutions has its own mission and, in many instances, its own procedures. Natural History is a scientific research institution that has long collected and studied human skeletal remains from people and cultures around the world, and their research continues today. The NMAI is, at its core, a museum about the history and culture of Native people of the Americas. Its mission is not necessarily related to scientific inquiry. And not surprisingly, these mission-related differences also account for variations in the way these institutions conduct repatriation. So let me dig into a few of those differences before I ask our panelists to share their thoughts. As I mentioned, perhaps the biggest difference is the role of the Smithsonian's Repatriation Review Committee, which oversees repatriation and disputes only at the Museum of Natural History and not at NMAI. So why is that? The primary reason is based on the language in the law, which provides that the NMAI Board of Trustees shall have sole authority over all collection activities. From the outset, NMAI has interpreted this to mean that its own board, rather than the review committee, must exercise exclusive authority over repatriation decisions, because to cede authority to the Repatriation Review Committee would be inconsistent with its sole authority as set out in the law. Now, over the years, there are those who have questioned this interpretation, but in my opinion, it has provided each museum with the autonomy and flexibility it has needed to conduct repatriation in the context of each museum's unique mission. So let me just highlight a couple of other differences between NMAI and Natural History and their philosophy and approach to repatriation, because I think it helps to understand why two museums within the same larger institution might reach different repatriation decisions. The first is the burden of proof, and you heard Kevin refer to that when he was sharing Rick's remarks with us. The NMAI Act provides that if a tribe can establish cultural affiliation by a preponderance of the evidence, which means more likely than not, then the museum must return them. From the beginning, this museum, the Museum of the American Indian, adopted a standard, a reasonable basis standard, which is more lenient than a preponderance of the evidence. And that might result in repatriations that this museum might agree to that Natural History might not. The second is the appeals process. The process for handling appeals of disputed claims is also different. At Natural History, appeals are handled initially by the review committee, which makes recommendations to the Secretary of the Smithsonian, who ultimately makes the final decision. At NMAI, the trustees render decisions based on recommendations from the Repatriation Committee. And if an appeal should arise, it would be handled by a special committee comprised of board members and senior Smithsonian management. Fortunately, appeals are exceedingly rare. In the 25-year history, there have been 2 appeals of decisions by the Museum of Natural History, and none of NMAI's decisions. The last difference I want to mention has to do with international claims and claims of non-federally recognized tribes. Because the law, by its terms, only applies to federally recognized American Indian tribes and Native Hawaiians, there is no legal requirement to repatriate to indigenous communities outside of the United States or to non-federally recognized tribes within the United States, such as state tribes. Given the press of pending repatriation claims from federally recognized tribes and resources that are understandably not unlimited, the Museum of Natural History prioritizes claims from federally recognized U.S. tribes and does not generally honor claims of international or state recognized tribes. Whereas, as you heard this morning from Kevin through Rick's comments, that this museum will repatriate both internationally and to state tribes. There's some other differences as well you'll probably hear about from our panelists, and I don't want to take up any more of their time.